You know, my own view is that there really was some, at the very least, low-hanging fruit in this debate. There were certain things, such as consolidating the SEC and the CFTC, that just seemed quite obvious. We are the only jurisdiction in the world that separates the regulation of securities and futures. The manner in which these products have developed over time makes some of them virtually indistinguishable, and huge amounts of time are spent in the government debating who has jurisdiction over the product, as opposed to whether the product will be approved for trading or under what circumstances. And that is that's very unfortunate, and in some instances has even resulted in the products being introduced offshore, you know, again, leading to competitive disadvantages for the U.S. markets because we haven't addressed these issues. So I think at this time it's sort of difficult to predict what the final details of the reforms will be, and I look forward to, you know, talking to my fellow panelists about the specifics of the regulations that are being proposed. But again, I thought that I would focus on sort of this missed opportunity for, you know, a consolidation of regulators and the regulatory structure. I have to say, also with respect to the CFPA, the thing that is one of the things that's most distressing there is not only are we creating a federal regulator, which, you know, people can debate, but there has been a move, sort of a reactionary move away from the notion of having any sort of federal preemption. And so what we have is sort of an aggressive move to almost encourage the states to weigh in on a number of these issues at a time that we're trying to also, you know, sort of consolidate and rationalize that system at the federal level. It's quite interesting if you look at what's being done. To the extent that those functions were performed in other federal regulatory agencies, what we're doing is preempting other federal agencies and yet encouraging 50-state activity in this area. So, you know, I suppose that ultimately it's not surprising that turf battles among regulators, the various stakeholders, and the competing interests have compromised our goals of simplifying financial regulation. But it is sort of interesting that after years of deregulation and the public reaction to the financial crisis and the resulting political sentiment seems destined to lead to the other extreme, more regulators and more regulation. And indeed, the focus on the competitiveness of our markets, remember that when we used to talk about that just a couple of years ago? That was a common theme, but it's pretty much been lost in the current public debate. And it's with this sort of cautionary note that I conclude, you know, as we're pondering the thousands of pages, as Judge Jones said, I think it's actually 1,136, but who's counting, of proposed legislation, including the Dodd bill, I hope that we don't lose sight of what should be our goal, which is the desire to have sound regulation, which I do believe in, balanced with efficiency and cost effectiveness in order to ensure the integrity of our markets. Thank you.
So I'm the wrap-up hitter here, and I guess we're seated here, Annette and I, at the end, and I don't know if you all remember Saturday Night Live from years ago, where you had the point-counterpoint, and Jane, you ignorant, whatever. You know, to disappoint you all, I'm not going to go down that because I think we agree more than we disagree. But it's a pleasure to be here, and thank you all for coming. At last year's National Lawyers Convention, I was privileged to be on a similar panel of distinguished legal scholars, moderated by the exceptional professor Steve Bainbridge of UCLA regarding the SEC and the financial services crisis of 2008. At the time, of course, the 2008 election had just been held, and the peak of the crisis of September 2008 was still very fresh on everybody's minds. Because the crisis was so recent, there was a lot of speculation in the country that the new administration would come right out of the starting blocks and enact very hastily prepared financial services legislation. Barack Obama had been on the campaign trail talking about how the financial crisis was caused by supposedly deregulatory policies during the Bush years, and I myself feared that a raft of new laws would engrave into stone all the wrong lessons from the financial crisis, plus, of course, the Democrats' favorite bent of rewarding their favored constituencies, including labor unions and trial lawyers. Well, 1 year later, some things have changed, but some have not. The memory of the financial crisis has faded a bit. The Obama administration has spent some valuable political capital on a stimulus package that was not, in fact, a stimulus package, but a great pork barrel package that, yes, rewards some of its favorite constituencies over the next few years to the tune of many hundreds of billions of dollars. And on top of that, of course, was the $700 billion TARP program, which was, of course, put into place by the Bush administration. And then Team Obama spent a lot of their time and political capital on environmental legislation that, of course, doesn't look like it's going to go anywhere. And then a $1 trillion health care bill that most of us in this room anyway hope will go nowhere. Their poll numbers are falling. They lost 2 bellwether elections in Virginia and New Jersey that the president campaigned heavily in, and even the special election in upstate New York that the Democrats won in a fluky election looks closer every day as recanvassing takes place and absentee ballots are counted. And so, of course, next year is another election year that both sides view as a rematch. So it's in this context that financial services regulatory changes are beginning to be debated. And I don't think anyone believes that a bill will be enacted this year. Too much is up in the air, and too many other things are competing for Senate committee and floor time. But to me, the situation makes me rather uneasy because it seems like it's 2001 to 2002 all over again. In 2002, both sides looked to the election as a rematch of the previous election in 2000, which of course was a cliffhanger. The House and the Senate were both considering bills in the wake of Enron, and each bill was different because each party controlled one chamber. And it didn't seem at the time in late 01 or early 02 that anything was actually going to be passed. But then along came a Bernie Ebbers, not Bernie Madoff, of course, and the WorldCom collapse, and then suddenly it was so close to the election that the politicians just did a headlong rush to pass anything. The Business Roundtable famously throws in the towel at a crucial time, undercutting the Republicans in the House of Representatives, and the Senate bill then, with a bunch of whistles and bells that were added to it on the Senate floor, becomes the Sarbanes-Oxley Act. So could history repeat itself next year? Could a collapse, for example, in the commercial mortgage space, a crisis over the value of a dollar, an international military event, or God forbid, a terrorist outrage on our home soil, spark a reaction in the financial markets that might lead to the enactment of some hastily crafted legislation? The lesson of Section 404 of Sarbanes-Oxley and Peekaboo, I think, should be enough to give most people pause. On the 3rd of December, to put that on your calendar for those of you interested in the Supreme Court, the court will hear a challenge to the constitutionality of Peekaboo. I think that it's a good chance that a majority of the court will find this particular entity unconstitutional. Now, theoretically, that result could bring Sarbanes-Oxley crashing down in its entirety because when it was being drafted, the drafters were a bit cocky and they didn't put a savings clause into the statute, even though the Republicans actually pointed it out to them. But I think it's probably likely that the court will give Congress a respite to correct the situation if they do find it unconstitutional. But the unfortunate side effect could be that it would provide a vehicle then for Congress to pass some of the ill-advised ideas that are percolating around the Hill. So put that on your calendar. But it's a positive development that a Financial Crisis Inquiry Commission is finally put into place and is starting to do its work. The idea here was to have an organized inquiry into the causes of the financial crisis, similar to the work that the Congress did back in 1933 and 1934 into the Pecora hearings. And this commission has subpoena power, and so we'll see what comes of it, but it's supposed to deliver a report next December. So what are the lessons from the financial crisis? Was it, in fact, caused by deregulation of the Bush administration? Well, I think that's hardly the case. I think all we have to do, and we can sit down and give a catalog of laws and rules and regulations and whatnot for the financial industry that came down during the years of 2001 to 2008. Sarbanes-Oxley, of course, led to the promulgation of more SEC rules in a short amount of time that the agency had ever done before. On top of that were New York Stock Exchange, FINRA, and NASDAQ rules that came out, and then, of course, the MSRB and the FASB with respect to accounting rules.